In National Association of Home Builders versus Defenders of Wildlife, the Supreme Court addressed the issue of conflicting shall requirements in the Clean Water Act and the Endangered Species Act. Under the Clean Water Act, a state can request that the Environmental Protection Agency, or EPA, transfer National Pollutant Discharge Elimination System, or NPDES, permitting authority to the state. The state must show that it has met 9 specified criteria before the EPA can transfer authority. None of the criteria address endangered species. The Clean Water Act holds that if a state meets the criteria, the EPA administrator shall approve the state's request. Under the Endangered Species Act, agencies are required to consult with the Fish and Wildlife Service, or FWS, to ensure that proposed agency actions won't jeopardize endangered species. Arizona applied to the EPA to gain NPDES permitting authority. The EPA consulted with FWS, which issued a biological opinion holding that transferring authority to Arizona wouldn't affect any endangered species. The EPA transferred authority to Arizona after it determined that Arizona met all 9 criteria in the Clean Water Act. The EPA held that the biological opinion from FWS satisfied the consultation requirement in the Endangered Species Act. Defenders of Wildlife sued the EPA. The National Association of Home Builders later intervened as a respondent. Defenders of Wildlife argued that the EPA's reliance on FWS's biological opinion was arbitrary and capricious, and that the EPA didn't satisfy the Endangered Species Act requirements when it granted Arizona's application. The EPA argued that once Arizona satisfied the 9 requirements in the Clean Water Act, it had to transfer authority. The Ninth Circuit invalidated the EPA's transfer. The National Association of Home Builders appealed, and the United States Supreme Court granted cert.